Mr. King, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the prosecution is represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Stitch McGuire. We are outside the presence of the jury. Are the parties ready for the jury?
Well, Judge, we've got a couple of issues I think we probably should talk about. The first issue is I've tendered to, I'm anticipating the testimony of Dr. Robert Hanlon this morning.
Yes.
I've tendered to counsel this morning a series of demonstrative exhibits that I intend to use with Dr. Hanlon. I'm not anticipating he's the first witness, but probably the second witness. I have a copy of those proposed demonstratives for the court, if I may approach.
Yes, please. Thank you.
I apologize for the staple being in the wrong place.
That's okay.
The only other issue, Judge, I think would relate to the testimony of Dr. Gray, and we have the issue surrounding the use of the data or the questions from the personality testing that Dr. Gray conducted. And we continue to have disagreement about that, Your Honor.
All right, let's take up the demonstrative exhibits first.
You want my position, Your Honor?
Yes, please.
I object to them. First off, Your Honor, I got them this morning, having never seen them before or anything like them. I'm not sure why it took until this morning to get them here. In addition to that, Judge, there are aspects of these that are not appropriate for demonstrative evidence. It just seems like we want to put up a slide that talks about Dr. Hanlon's credentials. And then there is information contained on some of these slides that has not been disclosed to us by Dr. Hanlon. I spoke with Mr. King about it specifically. There were some sub-tests that are listed in here with scores. Mr. King said that they were contained within his report. I reviewed his report, and I may have missed them, but I do not see some of these sub-tests in there. And for all those reasons, Judge, and I think the second to the last page is interesting. It looks like they have pulled some quotes out of books, and they just want to put up a slide of quotes to the jury. That doesn't seem like appropriate demonstrative evidence. I don't think the foundation can be laid for that. He can certainly testify to things that are within the disclosed opinion that he's provided, but beyond that, Judge, I don't think that's appropriate. And then the last page seems to be his own impressions of what 3 psychiatrists he believes have said about the defendant in this case. Also probably not an appropriate demonstrative. That's all I have at the moment, Judge.
All right, Mr. King, any response?
Thank you, Your Honor. First of all, just like in terms of timeliness, Judge, we've been in trial now for many weeks, and for many weeks the prosecutors have been coming into court and handing us exhibits right before the witness testifies, exhibits that they actually intend to introduce into evidence. So the fact that I sent these to Mr. Brockler at 5:30 this morning after receiving them last night when Dr. Hanlon came in on his flight, I don't think is a tremendous surprise. Secondly, Judge, demonstrative evidence is generally admissible if it's, number one, relevant, if it, number two, will assist a witness in explaining his testimony, and number three, if its probative value does not substantially outweighed by any prejudicial effect of that evidence. I don't intend to move to introduce any of these demonstratives, Judge. These are just exhibits which I would like to put on the screen while Dr. Hanlon testifies in order to explain his testimony. His testimony involves a lot of numbers, Your Honor. That's what neuropsychological testing is all about. It's about intelligence and cognition, and to have the expert witness just sit on the stand and rattle off numbers can be very confusing to the jury, I think, and giving them a visual representation of what is going to be the exact content of Dr. Hanlon's testimony, I don't think it's relevant, number one. It would assist him in explaining his testing and his conclusions based on his testing to the jury, and I can see no prejudicial effect whatsoever from showing the jury a visual representation of the results of the tests that he performed in this case. These have been provided in the reports. I just spoke with Dr. Hanlon, who's present in court, Your Honor. Every single piece of data that's contained in these exhibits, including the subscales, is included in his reports and the appendices to his reports that have been provided to the prosecution. In addition, the prosecution has had ample opportunity to interview Dr. Hanlon and ask them any questions they wanted about any topic. The other thing that is contained in are basically the first two slides are information that are contained in his CV, Judge, which they've had for some time. The third slide is just the different type of what a neuropsychological evaluation is.
So let me stop you there for just a minute. Have you disclosed all the information in the slides to them?
Yes.
Okay.
The only information in the slides which has not perhaps been disclosed in an actual report to them, Judge, would be the second to the last slide. The last slide is psychiatric evaluations and diagnoses, and it just basically lists the three psychiatrists and when they did their examinations and what their diagnosis is. And Dr. Hanlon will testify, as he wrote in his reports, that his findings are congruent with the diagnostic conclusions of all three of these doctors, including the two doctors that are the court's doctors. That's all that slide is for. The second to the last slide, Your Honor, has to do with cognition and intelligence in schizophrenia. And Dr. Hanlon has opined in his reports and in his prior testimony and discussed with the prosecution when they interviewed him the fact that Mr. Holmes is intelligent, that his intelligence falls in the superior range, and that affects the testing that was done, the results of the testing, and it affects the diagnosis that's been given. And these are just quotations from various articles in literature that's out there that form the basis for his opinion, Judge. It's common knowledge among psychiatrists and psychologists that intelligence affects the mental illness. I mean, it's just common sense. And so these are well cited here, Judge. They're in the literature, and there's nothing prejudicial about showing this to the jury. He's going to testify about this anyways. So again, I'm not asking to introduce any of these. All of the slides that contain data are information that have been provided in the reports and in the appendices, and there's just nothing new here, Judge. And I'm just trying to be able to make a presentation to the jury that they can understand, rather than the witness just sitting and rattling off numbers.
All right, thank you. The prosecution's objection is sustained in part and overruled in part. I will allow most of this, Mr. King. I think that there are a few slides in this, what appears to be a PowerPoint presentation, that I don't think qualify as appropriate for demonstrative evidence. So the first slide, which talks about his experience and apparently crime classification, the crime classification manual definition and the Park Dietz, D-I-E-T-Z, criteria definition of mass murders. I don't see how that assists in him explaining his testimony. I think that's just a way to highlight his testimony for the jury, and it's more appropriate for closing argument, if you will. And it sounds like it's cumulative in any event, because it's in his CV, and at least thus far, the defense has been moving the CV of each expert into evidence. And so if that's the case, then this is going to be cumulative in any event. And then the last two slides I don't think are appropriate either. The last slide contains a summary of what he believes the other experts concluded. Again, this is more appropriate for a closing argument. and I don't see how this helps him explain his opinions. And then the penultimate slide, that's the one right before that one, appears to contain some quotes from different authorities. And again, I don't think it's appropriate as a demonstrative exhibit during his testimony. It appears to have 4 quotes, and then in fact, right below that, it appears to have the authorities that the quotes came from. And these are quotes from the Psychiatric Association, DSM-5, from Russo, R-U-S-S-O, Murray, M-U-R-R-Y, and Reichenberg, R-E-I-C-H-E-N-B-E-R-G. Another one from Reichenberg, this one Reichenberg et al., and then from McCabe, capital M, small c, capital C-A-B-E. So I don't think that's an appropriate slide for demonstrative purposes, or it does not, in my view, it doesn't qualify as appropriate demonstrative evidence. But the rest of it, I think Mr. King is right. This appears to have information that I think will assist the testimony, assist the witness explain his testimony. There is one, for example, that contains a list of the testing cognitive functions or mental abilities. There's another one related to the neuropsychological evaluations of the defendant, and he divides them into the first evaluation and the second evaluation, how many hours per day, and how many hours per session each day. And I think it's hard to keep track of all those numbers. The next one is a symptom performance validity slide on malingering, and again, it contains a bunch of information and numbers. Next is intelligence testing, and it contains different categories and different information, including the composite IQ score range, the classification, and the percentage of the population. The next one is related to the intelligence testing that apparently was done in the defendant, and again, it compares apparently it has the score of the defendant's testing. It shows that he tested in the 94th percentile, and it shows that that's superior. Next one is related to that as well. The next one is related to the same thing. The next one is also on intelligence, and it contains different numbers, different classifications. Same with the next one, and apparently these were done at different times, and so that's why there are multiple slides related to intelligence testing. And then you have one that goes into specifics, vocabulary, information, similarities, block design, and it compares between April 2013 and January 2015, and then it shows the change in between. There's one on memory testing, one on executive functions testing, and again, all those have numbers, and there are numbers for each testing, and there are 2 different tests that apparently were conducted, if not more than 2 tests. There may be, for some of these, there may be 3 tests. April of 2013, August of 2013, and January of 2015. So I think those are appropriate, all right? So the objection is sustained in part and overruled in part. Mr. Brockler?
Your Honor, and I respect the court's opinion on that. In light of what the court is willing to admit, would the court consider there is some cumulative aspect to these, and I think the court probably saw that. Some of the same information that appears on individual slides is repeated in the subsequent slides. And if the court's going to admit those subsequent slides, can we just cut it down a bit and get rid of the initial slides that seem to just repeat the same information? And specifically, Your Honor, forgive me, can I move to the podium? I'm going to hold this up for the court because these pages aren't numbered, but there's a slide called Intelligence that has the FSIQ and the ranking for it, and then it has the subsequent one right behind it, and then it puts both of them on the same page with no new information, just a comparison. And then that same information appears, again, separated out on the next 2 subsequent slides, and then that same information appears on the 7th slide. And Judge, it seems like we could probably get rid of the first 2, if not the first 4 slides, and still not lose the ability to allow the doctor to highlight what's significant about those scores, whether they're superior, high average, and all those other things.
Judge, I would object to that. Dr. Hanlon created these slides for specific reasons. The importance is the correlation between these things, Your Honor. And this is not evidence, cumulative evidence that I'm seeking to admit before the jury. These are demonstrative aids. The jury's going to see them once, very, very briefly, and then they're going to go away. I was not allowed to hamstring the prosecution's presentation of their evidence through their witnesses, and I'm just asking to be able to present this information as I see fit, and that's why I'm not seeking to introduce these exhibits. I'm merely using them for demonstrative purposes, and this is the way that Dr. Hanlon thinks he can best explain his testimony, Judge, and the relevance of the various information.
All right, it is, there is some overlap, but I don't know what the prejudice is, and I don't think it's, it doesn't concern me enough to require that these a couple of additional slides be excluded. Mr. Brockler is right. There are at least 2 of these that appear to be, to add nothing, and that is the one that has the score for April of 2013. The title is Intelligence, James Holmes, Wechsler, Wechsler, and I am probably mispronouncing that, Adult Intelligence Scale, Roman numeral 4, WAIS, Roman numeral 4. There's one of those for April 2013, and there's one of those for January of 2015. And then the one that follows those 2 has both of those scores, and then he compares the 2. It has them all on one. So there is some overlap, but if the jury's going to see the same information anyway. If the testimony gets cumulative and a question has been asked and answered, then Mr. Brockler, you can object at that point, and we'll handle it that way. Okay? All right. Mr. King, do you want to retrieve this?
Sure.
And if you want to mark it as a court trial exhibit, you can do that, okay?
I think I'll do that.
All right. Okay, what's the next issue?
Your Honor, we were not able to reach an agreement on the issue of the underlying questions and answers to the MMPI-2 and PAI that I brought up. I should let the court know that in working with the defense and the Attorney General's office, the information that I received by way of offer of proof to the court is that neither Dr. Gray nor Dr. Manguzo have any ethical objection to getting either of those answers in or a paraphrased version of those questions, which I readily agreed to. And I'm not aware of any other objection that either of those mental health professionals who administered these tests have. My understanding is, and Mr. King can obviously speak for himself, is that the objection is that the answers should not be provided to the jury.
And you're intending to provide some answers to the jury?
Yes, sir.
So your intent, Mr. Brockler, is to explore some of the questions, but to paraphrase the questions. Is that right?
That's correct, sir, and that was in response to the Attorney General's request, I think, to try to protect some of the integrity of the testing process, and I agree with that. And I spoke with Dr. Gray about that this morning. He thinks that he can do that, and he didn't have any objection to provide, ethical objection to providing the answers to those questions.
Okay, and Mr. King, when we talked about this, I think yesterday, I think what you had said is that if Mr. Brockler went into any of the questions and any of the answers that are part of these tests, that then you would feel like you would need to move the entire test into evidence. Is that what the issue is?
Well, Judge, there are a couple of issues here. And the most important issue is how this evidence is presented to a jury. And I spoke with Dr. Gray about this last night, and Dr. Gray is present in the courtroom. I've also previously spoken with Dr. Richard Rogers, who's the prosecution's expert psychologist in this area. Both of these doctors have indicated to me very clearly that to proceed in this manner would be an inappropriate use of this evidence and would be misleading to the jury. This is a huge problem, Judge, that doesn't relate only to the copyright material that may be contained in the testing. These are tests which are only valid when taken as a whole. This is an article written by Dr. Richard Rogers in which he talks about the MMPI and what the MMPI is and how it works. And it's an overlapping test, Judge. The questions relate to each other and the scales that are involved. There are many, many scales and subscales that are involved, and they interrelate and overlap. And the only way you can accurately interpret those scales is through the statistical validity of the entire test itself. What counsel is proposing is to take a single question out and to impeach the findings of the psychologist with the answer of Mr. Holmes to a single question. In other words, if the psychologist says, well, we performed this test, Judge, and it indicates that Mr. Holmes scored high on depression, that he was depressed. That's one of the findings of the personality testing. The example that Mr. Brockler gave yesterday was that there was a question in there about hopelessness. Do you feel hopeless? And Mr. Holmes apparently answered no. And so what Mr. Brockler proposed is that he then bring that up. Well, doesn't that contradict the findings of the report that he answered to that question? And the problem, Judge, is that there are over 500 questions in this test. They're all true-false questions. Many of them have no right answer. They also, many of them, implicate issues that are forbidden by this court to talk about, including future dangerousness, remorse, all kinds of issues which are precluded from being discussed in open court. And, Your Honor, the danger is that it will be grossly misleading to the jury, because what Dr. Gray would testify to if he took the stand, and I'm going to ask that he do so, is that by singling out single questions, you lose any validity of what the testing results are.
Who scored the test? Is the test scored through a software, or is it a doctor actually scoring the test or drawing conclusions from it?
Either, Judge. There are both software packages available, and psychologists can score it themselves. So
these tests that we're talking about, how were they scored, or how did Dr. Gray reach conclusions from the test? Does he put in the answers into some computer software, and then the software spits out the conclusions? Or does he review it, and then does he in his discretion think, okay, I'm going to conclude X, Y, Z based on the answers that I see here? I mean, how does it work? I guess I need to know more about how the testing works.
Which is why I think you need to hear from Dr. Gray, Your Honor. And I think the answer, if you're asking me, I think the answer is both.
Okay.
I think they use software and then they reconfirm and use their own subjective judgment in order to interpret the test. In addition, you have to have specialized training to even use the software and interpret the results of the software. It's not something that anyone can do to interpret these tests. You have to have a PhD in order to interpret these tests, and that's why we have expert witnesses that administer the test. It's wrong to allow the jury to think that they can somehow interpret the answers to individual questions, and that should have meaning and relevance to them in the case. That would be an improper use of these instruments.
I understand that concern. I'm sorry to interrupt you, Mr. King. I get that concern. But I need to know more first about how the testing is done. I mean, I understand that there are questions and that the person being examined answers these questions, but I don't have a good understanding of what happens after that. I get the concern that we don't want the jury second-guessing and doing their own testing. On the other hand, there's also a concern for me that the parties are bound by what an expert says. Since when is that the case? I mean, if an expert is going to get on the stand and render expert opinions about something that he used his training and experience and his discretion in, he's subject to questioning. I mean, the parties are entitled to question him about the underlying facts and data, right? I mean, we're not, the judicial system is never bound. Just because an expert says, a psychologist says, well, I tested it and you need to take my word for it. Now, if it's different and it's just a matter of, hey, there's a software, we put in the answers and it spits it out, I printed it, and that's all I did, then I might see a difference there, because then it's not the expert who is interpreting anything. It's the expert simply saying, this is the test that we use in our field, this is the test that has been deemed to be a valid test that's used by everyone. I put in the answers in the software, the software spits out the conclusions, and here are the conclusions. In that case, I don't know why anyone would be interested in asking questions of the expert, because all he's doing is taking the answers given by the defendant and putting them into some software and having the computer do the work in terms of what conclusions are reached.
Well, Judge, I think, again, I really think that the court needs to hear from a psychologist to really answer these questions, because I am not a psychologist.
Okay.
And I'm not qualified to answer these questions either. But I think that what the answer is that whether it's scored automatically by a computer or whether it's scored manually, you have to follow certain procedures in order to accomplish that. So it's done in pursuant to a certain protocol, whether it's done in someone's head or whether it's done in a computer program. And I don't want the court to misunderstand. I'm not saying that Mr. Brockler can't question the results of the test. I'm not saying he can't question the way the test was scored. I'm not saying he can't question the opinions of the doctors at all. He can do all he wants. I'm just saying one thing, and that is, if the manner of doing that is to select out an individual question from an individual instrument and then impart some kind of meaning in the case to that, then that would be inappropriate. And I don't think that that's necessary, Judge, in order for him to accomplish those purposes. And frankly, I don't think that's why he's doing it. I think he's doing it to inject other evidence in front of this jury that would be inappropriate, frankly.
Well, I'm not going to allow any evidence that would be inappropriate, and I'm not going to assume that that's why he's doing it. But how do you suppose he should go about questioning the witness's conclusions if he's not allowed to ask questions about the questions that were asked in the test?
But he's allowed to ask questions. He's just not allowed to take an individual question and answer out of context and impart meaning to that, is what I'm saying, Judge.
But how does he do that? You have a witness who's testifying about a test that he administered, and you're saying, Judge, he's entitled to question him about his conclusions. He just can't ask about the test.
Well, no, he can ask about the test, Judge. We just can't ask about specific questions. Let me give the court an example, okay? There are many very, very odd questions on the test. Like, there's a question on the MMPI that says, I've always wanted to be a singer. Now, arguably, that has no relevance to this case at all, and no relevance to Mr. Holmes at all.
Here, give me a second. All right, go ahead, sorry.
But it does have meaning in context in light of the entirety of the test. So to parse out each individual question and ask why that question was asked and what relevance it has, or to impart some special relevance to the individual questions is the problem, Judge. And I have a case to cite for the court.
Hold on. Before you cite the case, since you gave me this example, let me give you an example. Let's say someone gave the answer that Mr. Brockler gave yesterday in terms of hopelessness about the future. And let's say someone said, no, I'm not hopeless about the future. But let's say that the person then answered the question, I want to be a singer. And let's say that a doctor draws a conclusion from those two answers and says, well, I know that he said he was not hopeless about, or let's say in the example that the defendant said, he doesn't want to be a singer. and let's say the expert comes in and says, I know that he answered the question about hopelessness in the negative, but he also said he didn't want to be a singer. And so based on that, I concluded that he was hopeless. I'm just giving you a hypothetical example. In that case, if the conclusion was drawn from those two answers, it seems to me the parties would be entitled to explore that. Now, if there's a testing protocol that he's following that says, hey, if the answer X is given to this question, and then an answer Y is given to this question, then the conclusion is whatever, then that may be different. If all he's doing is a mechanical task where he's testing it based on what is understood in the field and has been accepted in the field, and he's not exercising any of his discretion, he's not using his background or experience to draw any conclusions, he's simply doing a mechanical task that anyone could do, then in that case, I would agree with you that nobody should be asking him questions about the conclusions he drew or how he scored the testing, how he viewed the results of the test. But if he's exercising discretion and he's drawing conclusions based on his training and experience, and those conclusions might differ if someone else were looking at the same answers, then it seems to me that the parties should be allowed to question him about that.
Well, I think it's more like the former than the latter, frankly,
Okay.
Judge. I think it's more that if you do the procedures correctly, the result comes out the way that it comes out. And the question is, did you score it correctly? Did you administer it correctly? You know, there's no interpretation that the psychologist makes of the individual questions. Absolutely not. The psychologist doesn't look at, well, he answered, about that he wants to be a singer, therefore I draw specific conclusions from that. That absolutely does not happen. What does happen is the totality of the test scores are either inputted into a computer program or inputted into a statistical algorithm or whatever they do to manually calculate it. And if it's done correctly, the results are spit out, like you said. And it's never a question of the psychologist subjectively interpreting the answers to the individual questions, which is why it would be inappropriate for the jury to do the exact same thing.
All right, maybe I should hear from Dr. Gray sooner rather than later.
Okay. One other issue I wanted to bring to the court's attention that had to do with the proposal by Ms. Wheeler, who's present in the courtroom, and that was that her suggestion was that rather than asking the actual questions on the test, which they have an objection to, that we ask paraphrased questions from the test. This causes a whole nother set of problems, Your Honor, because paraphrased questions are not the way the test works. The test is based on the interrelated nature of the questions and the scales involved, exactly the way it's been put together. You can't paraphrase the questions and then give the answers Mr. Holmes gave to the actual questions and then interpret the results of it. That just can't work, Your Honor. So the proposed solution is really unworkable, in addition to the underlying problem that I suggested. And if I could, Your Honor, the case that I would ask the court to take a look at is Fisher versus Johnson, 508 Northwest 2nd, 352. It's a 1993 case out of New Jersey, I think, North Dakota. We could find no case law in the state of Colorado, Your Honor, but that's a case that discusses this issue and whether or not it might meet the required standard of admissibility of evidence to proceed in this fashion.
Okay.
In terms of questioning.
All right, thank you. Mr. Bruckler, and then I'll hear from Dr. Gray. I'm assuming, Mr. Bruckler, you don't have any objection to me hearing from Dr. Gray.
Not at all.
All right.
Not at all. Judge, I appreciate Mr. King trying to frame the reasons why I'm getting into this, but I want to tell the court, I'm not trying to just impeach the test. There are a number of reasons why getting into these things would be important. One, the jury is entitled to know if the psychologists interpreting these things even rely upon the individual answers or look at them or see if they're consistent with statements made to them by the defendant. If Dr. Gray, in his examination of the defendant, were to have asked the defendant, do you feel like you're possessed by evil spirits, or words to that effect, his answer to that undeniably would be relevant to an analysis of his mental health. And I don't think Mr. King would object to that. Well, guess what? That question is in the MMPI too. There are questions about feeling like your mind is under control by someone else. There are questions about depression, about hopelessness, about hallucinations, both audible and visual. There are all these true-false questions. So whether or not they have some interpretive value, they are unequivocally statements of the defendant about specific questions about his mental health. And independent of any impact that they would have on questions about whether he likes to jump rope or a singer, those are things that should be given to the jury. And I'm at a loss to understand how his answer of true or false to the question about being possessed by evil spirits is somehow misleading to the jury. So we can put Dr. Gray on, but he's going to tell you that out of those 567 questions, there are a number that seek specific factual things from the defendant that he answers yes or no to.
All right, that's a different thing than challenging the results of the test and the conclusions that Dr. Gray drew from his examination. Are you also intending to go into the questions for that reason?
Well, Your Honor, to the extent that, and I can tell the court, having spoken with Dr. Gray, my offer of proof is what he'd say is the report that's generated by the MMPI-2 software is automatic. He doesn't go in, he doesn't edit it, he doesn't look at it to see if it, he doesn't do that. His big thing is to look at the scales that are generated based on some grouping of answers, and then he interprets the scales, never looking at the individual questions. Well, one, the jury ought to know that the individual questions themselves are not factored into this. It is some software's way of manipulating these things around. That's important for the jury to know. But to the extent that that report becomes part of his opinion, and there are parts of that report, and I highlighted this yesterday for the court, where it says the defendant is hopeless. There's one question out of 567 that talks about him feeling hopeless. And in August of 2013, the defendant said false. They should get to know that if that's part of the manipulation of the underlying data. We should get to examine about that.
All right, is Dr. Gray present?
It is, Your Honor.
Dr. Gray, good morning. Is anybody requesting that he testify under oath right now, or yes?
No, sir.
Mr. King?
I think that would be the most appropriate thing, Your Honor.
All right. Dr. Gray, why don't you come up, please? If you would come around this way, please. Thank you. Let me have you raise your right hand so that I can administer an oath. You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, please be seated. For the record, could you tell us your full name, please?
Yes, it's B. Thomas Gray, Gray.
Thomas is the common spelling?
Yes, Thomas.
Thank you. Doctor, you've heard, I think, most of the discussion that the lawyers and I have been having here this morning. I'm interested in knowing more about the tests that were administered, and I think you've heard my concerns, and I think you heard what I said to Mr. King in terms of seeing a difference, at least in my mind, between sort of a mechanical task of scoring a test versus having someone exercise some type of discretion based on training and experience to draw conclusions from answers provided to a test. And perhaps there's some of both going on here, but I just need to be educated more about these tests. So could you do that?
I will certainly do my best, Your
All right,
Honor.
thank you.
The way that the MMPI works and the PAI is similar in its general construction and use. The MMPI consists of 567 true-false questions. The individual is given a test booklet with the questions in it. They mark on an answer sheet true or false to each question. I then take that answer sheet and I input the responses into a scoring program. That scoring program then calculates, for our purposes, the scales of primary interest are 7 validity scales and 10 clinical scales. Each of those scales is comprised of groups of items selected from the 567 that have been, each group has been empirically shown to correspond to particular characteristics. After I put the individual responses into the computer, I then get a printout that does include some interpretive statements. I consider those, but that by no means is all that I rely upon. I consider the scale scores. I make sure it's a valid profile, that the individual has not attempted to distort their responses to either look better than they are or worse than they are, and also to make sure that they've responded consistently. I then look at the clinical scales, and what seems to be particularly at issue here is the fact that scale 2, which unfortunately is labeled the depression scale, and I should emphasize it, that does not mean that it corresponds directly to the DSM version of what depression is. It's simply depressive characteristics. In this instance, Mr. Holmes produced notable elevations on scale 2. In my report, then, I reported a number of the common clinical correlates to an elevation on scale 2. Many people with elevations on that scale show these kinds of characteristics. That doesn't mean that each individual with a high score on scale 2 has every one of those characteristics. It's a broad characterization of what the test indicates that person is reporting.
Okay, and what about the PAI?
The PAI is similar. It consists of 344 items, and for each one of those items, the individual has 4 possible response options: false, sometimes true, mostly true, and very true. From that point, then, it is quite similar to the way the MMPI works. I put the individual scores into a scoring program. It gives me scale scores, and I then consider those and the typical clinical correlates to those scales.
And for the record, what does MMPI stand for?
That is the Minnesota Multiphasic Personality Inventory.
And the PAI?
Is the Personality Assessment Inventory.
Okay. All right, I'll give the parties a chance to question him if you like. We're outside the presence of the jury, just about the topic that we're talking about right now. So do you have any questions, Mr. King?
Yes, sir.
Yes.
Doctor, when you administer one of these personality inventories, do you ever look at the individual answers to the individual questions and draw any subjective conclusions from the patient or the defendant's answers to individual questions, or do you draw any conclusions or subjective analysis that you make from the scales that are produced by the computer program, the statistically based computer program that you just described?
It's actually a little of both. My primary conclusions are drawn from the clinical scales. Assuming the validity scales are okay, then my primary conclusions are drawn from the clinical scales. Now, for both of these tests, there are a series of individual questions that have been identified as what are called critical items. And these are items that potentially convey specific content that might be of interest. If the individual responds in the scorable direction to critical items, we also, in the computer printout, we get a list of those items. And it's often useful to inquire about at least some of those items just to explore a little further.
To inquire of whom?
Of the person who's being tested.
Okay. Would that affect your interpretation of the test or your clinical findings or both?
It could potentially. It doesn't necessarily, but it could potentially.
What about in this case?
In this case, I don't believe that the critical items revealed anything that was particularly surprising or that caused me to significantly alter the conclusions that I would have drawn just from the clinical scales.
So in this case, there were no follow-up on any individual questions. You derived your opinions from the clinical scales? Is that what I'm hearing?
No, I did inquire about some of those critical items, and I believe in the copies of the 2 MMPIs and the 2 PAIs that were administered, you can see my individual notes.
Right. But did you draw any conclusions from that affected your opinions?
No, I don't believe I did.
Let me ask you, there's a lot of very strange questions. Would you agree with me in the MMPI?
Yes.
And if you were to read the questions out of the context of the test, could you infer meaning from individual questions that are not meant to be imputed by the test in its entirety?
The core of MMPI interpretation, and it's also true for the PAI, is based on groups of items, not individual items. So I hope that answers your question.
Is there a danger then in placing too much credence in individual items or in presenting the answers of individual items to the jury and allowing them to infer what they wish from it? Could they misunderstand the test and the results of the test as a result?
I suppose that is conceivable.
Do you want to elaborate on that?
Well, I'm trying to think of a specific example, and there's nothing immediately coming to mind.
How about a question like, there seems to be a lump in my throat most of the time. Could that be interpreted a number of different ways about a number of different issues that wouldn't be what the test is considering?
It probably could be taken in a number of different ways, yes.
How about, I'm sure I got a raw deal from life? I mean, could you infer all kinds of meanings from that the test doesn't mean to infer necessarily, unless they're coupled with the other items? I think you said the meaning comes from groups of questions, the answers to groups of questions. Is that right?
Yes, the essence of MMPI interpretation is based on groups of items.
Do you know what specific questions Mr. Brockler is seeking to ask you about, or how many of them there are?
He has discussed one item pertaining to hopelessness. That's the only one that I'm aware of. I don't know how many there might be, nor do I know fully what his intention is.
Yes.
When you testify, and you've testified a lot about the MMPI and the PAI, is that fair to say?
I've used these tests in a number of cases that have shown up in court, yes.
And when you do that, do you draw your conclusions based upon the scales and the overall interpretations of the tests, or do you normally go through individual questions and interpret the answers to individual questions subjectively on your own?
The essence of the interpretation is always based on the clinical scales, the groups of items, rather than review of individual items. One other point that is perhaps relevant and that I should have mentioned earlier, the critical items show up on the list that is in the printout because the individual responded in the scorable direction. So in most situations anyway, those items ought to have been contained within the clinical scale elevations, the clinical scale scores.
And you said that in this case, you drew none of your conclusions or opinions from those critical items or your follow-up on those critical items. You drew your conclusions from your interpretations of the overall scales?
Yes, I believe that's right.
Is the point of the, Mr. Brockler in his argument to the court that you were here for just talked about one of the things that he wanted to put in front of the jury was the actual factual information that would be transmitted by the answers to the questions. Is the point of the questions in the MMPI and the PAI to obtain individual factual information or statements of fact about what happened or what in the person's life or the history of the person? Or is the purpose to see patterns of thought and behavior that tell us something about the personality traits of the person involved?
It's the groups of items that are really the most telling. Those are what have been studied at tremendous length. The PAI is it's 70 years old, so there have been countless studies, always based on groups of items.
Are you aware of any one study that says it's a good idea to single out specific questions, put those in front of the jury, and allow the jury to interpret the results or the answers to that question how they see fit? Would that be an appropriate use of this instrument?
I'm not aware of any studies that have advocated for that.
Do you have an opinion about whether that would be an appropriate use of this instrument if the jury were allowed to hear the answers to individual questions and then from those answers to individual questions call into criticism or not your opinions based upon the testing that you did?
To some extent, it seems to me the answer to that question is really in His Honor's purview rather than mine. I would again, though, simply note that the MMPI was not designed for, nor has it typically been studied on consideration of individual items. It's the groups of items in the scales that we rely upon.
Thank you, Doctor.
All right, Mr. Brockler?
Doctor, when you give instructions to someone on taking the MMPI, do you tell them, don't worry about being accurate on the individual questions?
No.
What do you tell them?
There are standard instructions. They're printed on the examination booklet.
Are they encouraged to answer truthfully, accurately?
I don't recall that either of those words are actually contained within the instruction.
Is that your expectation?
Yes.
Now, can you tell me what would be misleading about the answer to a question, evil spirits possess me at times? Is that misleading as to the issue of whether or not the person believes evil spirits possess them at times?
At least on the face of it.
No.
As far as I can tell.
Right. And there are a number of questions in here that seek things, you'd agree, that deal with visual hallucinations the person may be experiencing. Is that fair?
Yes,
Audible or audio hallucinations. Fair?
yes,
Their demeanor or mood. Fair?
yes,
Social interactions. Fair?
yes.
And there's nothing misleading about the facts in each of the individual questions, correct?
At least on the face of it, yes, I would agree with that.
Okay. In fact, you've talked about the computer generates, and I'm holding up one of the copies of the MMPI too, the one from August of 2013. The computer generates what it concludes are critical questions, fair?
Yes,
And you actually go back through, sit down with this guy, and individually go through a further explanation of what those answers mean in your discretion, correct?
I do with some of them. I don't typically follow up with each and every one, but I do with some of them.
And fair to say you exercise your discretion in which questions to follow up on, correct?
Yes, typically, in reviewing the critical items, I can see that there's a reasonable amount of overlap, and so I don't necessarily need to inquire about each and every item that shows up on that list.
In your professional discretion, correct?
Yes,
And you and I might have a disagreement about what you should have followed up on, correct?
potentially.
Okay. And it would be fair to have a conversation, questions and answers, about the questions you chose to follow up on and not to follow up on. You'd agree with that?
Oh, we could discuss that.
You know, I'm not saying I'm going to win. I'm going to say we can have that discussion. You agree?
Yes,
Nothing
it might be brief, but we could have the conversation.
Nothing misleading about that discussion, right?
I would hope not.
And in fact, if you were to be asked about individual questions in the MMPI-2 and the PAI and their answers, you'd be in a position to explain why you think those answers are relevant, not relevant, the importance of them. You'd be in a position to do that in your opinion.
Potentially I would, although, again, that would not have been anything that I used in formulating my opinions as stated in my reports.
In fact, one of the questions you followed up on, Doctor, was the defendant telling you, oops, I gave the wrong answer. I meant to give a different answer, correct?
He did reverse his answer on one question, yes.
And finally, you're not saying that the MMPI-2 shouldn't be subject to scrutiny, right?
No,
And you're not saying you shouldn't be subject to scrutiny in either how you conducted the evaluation or the responses and your opinions. You're not saying that, right?
that's correct.
May I have a moment, Your Honor?
You may.
Doctor, this is more of a scientific question, but you're part of the medical science world there. When you read an article, a peer-reviewed article, drawing some conclusion or offering some hypothesis, it's important to you to have the ability to access and scrutinize the underlying information to determine if you agree with the opinion, or do you just take everything you read at face value?
Relevance.
Overrule.
Go ahead, Doctor.
I typically look closusly at how the conclusions were drawn. The truth of the matter is that we almost never in published articles have the raw data that the study was based on. But I at least am able to look at the methodology that was used and draw some conclusions about whether or not the findings of that study are well supported.
And you think it'd be important to be able to scrutinize those findings by looking at the underlying evidence if you disagreed?
We almost never get that opportunity, although there would certainly be occasions when that might be nice.
Thank you.
Doctor, I have a couple of follow-up questions.
Yes, sir.
How many times have you administered these two tests?
Geez, I'm not sure, Your Honor. Over the last 20 years, hundreds.
And are these the kind of test results that can be reviewed by other experts who are familiar with the MMPI and the PAI and who can then either criticize or agree with the results? In other words, based on the documentation and data that you produce, can someone else with your expertise look at it and say, wait a minute, I would not have drawn this particular conclusion because of X, Y, Z? Or is it the kind of thing that it would be impossible for another expert to do?
No, it is possible for another well-trained person to review the information and to draw their own conclusions. And in fact, that did happen in this case.
Okay, tell me about that.
Dr. Reed asked Dr. Rogers to review my data. It appeared from reading Dr. Rogers' report that he was not provided with my conclusions. He was simply given the data and asked to reach his own conclusions.
His own conclusions from the data produced by the tests?
Yes.
Okay. In your opinion, if 50 different psychologists looked at this same data, how many different opinions do you think they would come up with? Or do you think they all would be, generally speaking, in agreement on the conclusions? I mean, perhaps not on every detail, but in general terms, do you think that given the standardization of the test, that they would generally come to the same conclusion if all they were doing is looking at the data and coming to conclusions based on the test results?
In this instance, I think at least most of the 50, there's always the strange individual in the bunch, but most would, I think, draw essentially the same conclusions Dr. Rogers did.
Okay.
So
Dr. Rogers differed a little bit from you, but in general, it was the same conclusions?
Yes.
Okay.
Yes.
All right.
And that's, I think, in part because the data that emerged from this testing was relatively clear.
Okay. All right. Thank you, Doctor.
Thank you, Your Honor.
I'm going to step down for a few minutes and think about this, and then I'll come out and we'll proceed, okay?
Judge, may I please just constitutionalize my objection very briefly?
Yes, go ahead.
401, 403, due process, fundamental fairness, the right to present a fair and to present a defense, the right to a fair and reliable sentencing hearing, United States Constitutions 5, 6, 8, 14, and the commensurate sections of the Colorado Constitution. Thank you.
And can I draw the court's attention to a scheduling issue?
Oh, hold on. Mr. Brockler, were you going to say something?
Yeah, I failed to give the court something. I might have asked the witness this. He's still here. I have copies of all 567 questions of the MMPI-2 as well as the questions asked in the PAI. I'd like to give those to the court to consider, to look at the individual questions. I've picked out a couple, but it may help the court at least in assessing whether or not there are factual questions in there that, if the court's interested, I can give those to the court.
Sure.
I have no objection to that.
All right. Thank you, Mr. King. All right, Ms. Spengler.
I just learned that Detective Madonna needs to be out of the courthouse by noon today. I just want to let the court know that.
No, you can give it to my staff. That's fine. Thank you. All right. We'll be on break for a few minutes or 5 minutes. Thank you.